safe. Today we are speaking about shareholder agreements, and specifically we're speaking about transfer and valuation. Previously we've done some talks giving an introduction to shareholder agreements. What are the common clauses that form shareholder agreements? What are the clauses that would benefit minority shareholders or majority shareholders? We've also done one where we've explained what are the implications and how do the courts in Malaysia tend to treat shareholders if they either have or don't have a shareholder agreement, or if they have a badly drafted one. So today we're going to dive into another area of shareholder agreements. We're going to talk about transfer and valuation. And before this, we have skimmed across some of these slides in passing, but we've never done a proper dive in because transfer and valuation in regards to shareholder agreements are a bit more complex, and they're subject to quite a lot of dispute before signing the shareholder agreements and sometimes after. So let's dive in. First, here's the outline. We're going to look at what are shareholders agreements. We're going to look at a transfer of shares clauses, which is the transfer part. We're going to look at valuation clauses, and then we're going to do a conclusion and Q&A. Now, first one, what is a shareholders agreement? As we've covered before, a shareholders agreement is an agreement. It's a contract. It's governed by the Contracts Act, and it governs the relationship between shareholders of a company. And it should also set out how disputes are to be resolved if and when they arise. There can be shareholders agreements can be between all the shareholders in a company or between only a few shareholders. And what is important to remember, there is no legal requirement in Malaysia to have a shareholders agreement, but we really recommend having one because relationships do turn sour whether we like it or not. And having one can protect your interests as a shareholder of a company. Now we're going to talk about the next part, which is two important elements to a shareholders agreement, which exist to facilitate the exit process. And this is the transfer of shares and the valuation of shares. When everything is going fine with a company, everything is fine and everybody is happy with each other, then everything is fine. But when drafting a shareholders agreement, we should always consider what happens if things don't go fine. What happens if one day the shareholders of a company want to break up with each other? At that point of time, what are the considerations that goes in to protect the interests of either the exiting shareholders or the remaining shareholders? And these are the type of clauses that we'll think about in just a bit. Other than this, there is also another very important question, which is if somebody is exiting the company and the shares are to be sold, whether to the remaining shareholders or to a third party, the biggest question is how much would the shares be worth? And the reason why this is important is because when you start up a company, your shares are worth like maybe a nominal sum of 1 ringgit per share. Okay, maybe you put in 100,000 ringgit into the company for those block of shares. But 5 years later, if the company is doing profitably, those shares are probably not worth only 100,000 ringgit. So the question is, how much are they worth? We'll cover that in just a bit. Now, a lot of shareholders agreements have these kind of clauses, which is a general restriction on the transfer of shares. And this can help you in certain circumstances. But these clauses normally go like this. No party shall transfer, grant any security interest over, or otherwise dispose of any share unless permitted or required under this agreement. So it generally goes in that way. You cannot simply transfer as you like. You cannot just say, I sell it to my friend. There can be certain rules and implements that we will go through. But at the outset, there's normally a restriction on transfer of shares. And this can also be time locked in the sense that you can say there's no transfer of shares within X number of years. And you might see this in situations where you start up a company and you know that it will take a minimum number of years before the company can grow into a full-fledged business. So you want to make sure that both shareholders, or if there are more, all of the shareholders are committed to making sure that the company at least gets to that level where you are able to say that the company has given a good shot at being successful. So these are the kind of situations where you might want to put a restriction on the transfer of shares. Now we're going to look at the types of clauses that are normal when it comes to a transfer of shares, and we'll explain a little bit on each one. Now, first set, and we call this a set because they're a bit similar, is drag along rights and tag along rights. And we've covered this before in previous talks, but we'll cover them again. Now, drag along right basically goes like this. If I am a shareholder of this company and I choose to sell my share to somebody else, and we have a drag along right in the shareholders agreement, then at that point of time, I can force the remaining shareholder to also sell their shares to this third party that I'm selling to. So when I sell, I drag you along. That's what the drag along right means. Now, a tag along rights is similar, but slightly different on who does what. A tag along right means like this. If I were to sell my shares to a third party, then the remaining shareholder gets a right to say, okay, I want to tag along to your sale and I want to sell my shares to the third party for the same price and on the same terms. Therefore, there must be a clause that says, if I offer to sell to a third party, I must also inform the third party that the remaining shareholder has a right to choose to sell, and the third party must buy, or else there is no deal. And that's what a tag along right is. So you can see that drag along right and tag along right is very similar. That's why they're named slightly similar as well, but they differ a bit in terms of the operation. Next, we look at ROFO and ROFERs, the right of first offer and the right of first refusal. Okay, so a right of first refusal works like this. A right of first refusal means that if I want to sell my shares, okay, and I have a price in mind, and I've located a third party who wants to buy my shares, before I offer my shares to be sold to the third party, I must first offer to the remaining shareholders, for the remaining shareholders to buy my shares at the exact same price and terms as what I'm doing that. So they get the right of first refusal. They get the first right to say, no, I do not want to buy your shares. Go ahead and offer them to the third party. That's what a right of first refusal means. And a right of first offer is, again, this is a set, it's slightly similar but a bit different in operation. Right of first offer means before I sell my shares to a third party, okay, I must inform the remaining shareholder that I'm intending to sell, and the remaining shareholder gets the right to make a first offer. And once the remaining shareholder makes that offer, it's up to me whether I want to accept or not, but I must give them that chance. Okay? Now, we'll look at the next set of shares, which is a put option and a call option. Now, put option and call option, normally what we see is that this is used in situations where we know that either party has a lot of money, or either party is very protective over the company that they're trying to form, and would do a lot to maintain certain important things like control of the company's business. And I'll explain all that in a bit. But normally these type of clauses, you don't see it for something where shareholders are just throwing money into a business just to invest. Okay, now explain what the put option and call option mean. A put option means at any time or under certain circumstances, depending on how you draft it. But when this clause is triggered, one of the shareholders can say, I put down my shares. And what that means is when I put them down, the remaining shareholder has to pick them up. Okay, that's the layman way of thinking about this. But what it actually means is that one of the shareholders gets the right to say, I force you to buy my shares. Okay, and the remaining shareholder will have to purchase those shares. Now, a call option is similar, but it's an inverse. It's a mirror of the put option. A call option means one of the shareholders will say, I now want to buy your shares, and the remaining shareholders have to sell their shares to them. And you'll see put and call options being used in situations where, for instance, if let's say I'm a shareholder who wants control of this company, and I do have the money to back it up, I will put in a call option, which means whenever I don't like you, I will buy your shares. Okay, and that's where you use a call option. And a put option, you use it as an inverse, where you know the other party does have the money to buy you out whenever, and they would want to. You can put a put option into the shareholders agreement, and whenever you don't like the other person, you're saying, look, I'm exercising my put option, I'm putting my shares down, now you have to buy them. Okay, so these are the slightly more common clauses that you will see in shareholders agreements when it comes to the transfer of shares in Malaysia. The biggest question is, when you exercise this kind of transfer of shares, what is the value of the shares? We will come to that in a bit. What's the common way that businessmen in Malaysia deal with the valuation of shares? But before that, we're going to look into something a bit more niche. We're going to continue on transfer of shares. We're going to look at these type of clauses that come next. They're not very common nowadays. And I'll be honest, all of them have names that are slightly racist. And I'll get to that in a bit. Now, next one is the Texas Shootout. So these are all very interesting. They're very interesting names. And again, these are not very common clauses nowadays. But since we're diving into transfer of shares, I thought I'd cover them as well. Now, there are two variants to the Texas Shootout, but it's a bit similar. The first variant is where each shareholder makes an offer for the other shareholder's shares. Then the other shareholder will either accept the offer or they will offer a higher price. Okay, so it's either you accept or you counter propose with something higher. This goes back and forth like a ping pong match until one of the shareholders give up and say, oh, sorry, I cannot offer to buy your shares at such a high price. Then that shareholder who gives up will have to end up selling their shares. Another variant is a sealed bid auction. What happens here is that each shareholder will submit an unseen bid for the other shareholder shares in the company. So what I will do is I will say, okay, I will bid to buy your shares in the company for, let's say, 100 ringgit. Okay, and then the other shareholder will do the same. What happens next is an independent party who acts as an overseer will collect the bid, and the bids will open at the same time. If I offer to buy the other shareholder shares for 100 ringgit, but they only offered 80 ringgit to buy my shares, what that means is I now have to buy their shares at 100 ringgit per share or something like that. All right, that's how it goes. Now the next type, okay, first one is a Russian roulette. The way the Russian roulette works is a shareholder names the price at which he values his share of the company. Okay, so an example of this is I think my shares are worth 100 ringgit. The remaining shareholders then have two options. The first, they can either sell my shares for 100 ringgit or they can purchase my shares for 100 ringgit. Okay, and then they will be more complex. This is just like a first round of how to transfer the shares, and then if that doesn't work out, there needs to be another clause after that. So you can mix and match these options as long as they make sense. Now the next one is called a Mexican Shootout, and I'm not kidding. I didn't come up with these names. This is similar to the second variant of a Texas Shootout. The only difference being that the shareholders submit the minimum price at which they would sell instead of the maximum price at which they would buy. So the shareholder offering the highest price must buy out the shares of the others, but at the lowest price. Okay. Now, the last one. We look at the 100% buyout deadlock clause. The way this works is like this. Let's say there are two shareholders in a company. 100% buyout deadlock clause means that one shareholder, let's say me, will, for a set period of time, let's say 3 months, I must go and find another person to buy 100% of the shares. So both my shares and the remaining shareholder shares. for the same price. Okay, if I do not find such a person within 3 months, then the authority moves to the remaining shareholder to go and find someone in the 3 months. This continues until all of the shareholders have had a go at finding that person to buy out all the shares, at which point in time you will need to have another way to sort it out. Another solution will have to be agreed upon. Now, these clauses are not very common nowadays, but we thought we go into them because they're very interesting. Now, we move on to valuation of shares. Okay, these are the common methods to establish the value of shares. You do the periodic price setting strategy, or you can use a predetermined formula. You can engage in arbitration or mediation. You can use third-party valuations. Now, I'm only going to touch on the first few methods, and we're going to go a bit more into the third-party valuations. Now, one of the problems with using a predetermined formula is that when you use a predetermined formula at the point that you're entering into a shareholders agreement, what you are doing is you are projecting, you're estimating, or let's be honest, you are guessing what is the value of shares in the future. So the way this might work, okay, the simplest method to do this is to say, okay, within 1 year, everybody agrees that their shares would have increased 10% in value. In the second year, another 10%, and so on and so on and so on as it goes along. This is a very simplistic method of determining the valuation of shares. But the downside to this is, if the company does very badly, the shares will be sold at a price which doesn't reflect their value. On the other hand, if the company does supremely well, the value of the shares using predetermined formula, it will be very lacking, and it will be very bad. It will be not in the best interest of the party who is trying to exit. The shareholder is trying to exit the company. So that's the danger. But this is a bit more simple. Another method is to say, let's say, both parties agree. At any point in time, when a shareholder wants to exit, the valuation of the shares will be net profit times 3 years, or EBITDA times 5 years, something like that. You can use whatever formula you like, but the point is that there is a predetermined formula that you cannot escape from unless you amend the shareholders agreement. Okay, so that's why it's not so useful. Now, if you go for arbitration or mediation, that is a viable option, but number one, that will incur further costs. So you have to think about what kind of company you're running, how big is it that you want to go for arbitration or mediation. And arbitration or mediation as a matter of valuation would be good if parties want to calmly exit the company. But arbitration or mediation would be less useful if parties are in dispute. If parties don't like each other, they're in shouting matches, they cannot stand the side of each other, then arbitration or mediation may not be the best way to go through. And the issue of cost when it comes to arbitration is also a big matter as well. Now, one method that we see is very common in Malaysia is to use third-party valuations. Okay, and this is viable for a lot of companies, except for the fact that shareholders must factor in the cost of the valuation. And we'll touch on that very quickly when we go through third-party valuations. Now, these are the common methods to draft clauses when it comes to the valuation of shares. And they're all pretty much the same thing, just using different names. Okay, the first is shareholders at the point of entering into a shareholders agreement, they agree on a specific valuation firm. So they appoint one specific valuer, and that specific person will produce the binding valuation. The second method is to say, okay, here's a list of suitable valuation firms, okay, from which shareholders can agree to select the valuer when it is required, and the selected firm will produce the binding valuation. Now, when you see these kind of clauses, most shareholders like to use, okay, we just call them, the suitable valuation firms will be the big four, habis. And then that's the end of the matter. That's their list of suitable valuation firms. That's what we normally see. Now, the third one is where shareholders, at the point of the valuation of shares, when the valuation needs to be done, at that point, they'll jointly appoint a single third-party valuation expert. Okay, which again is not very feasible if parties are in dispute. Now, number 4 is where shareholders each appoint one valuer who will then appoint a third valuer who will then jointly appoint the third valuer, and the third valuer will be the one to produce the binding valuation. Okay, the fifth method is shareholders both appoint a valuation expert who will give a valuation price. And what you do is you take the average between the prices. Okay, the sixth method is where all shareholders appoint a valuation expert, and those experts appoint one more expert. Out of the 3 valuation prices produced, the middle price is the one taken as a binding valuation. And last method that is commonly seen is where shareholders cannot agree on the prices produced by the experts, an additional expert is then hired to choose one of the original valuations as the binding valuation. Now, as you can see from the past 7 examples, they're all about the same thing. They're all about trying to get to one specific valuation price, one specific price per share that is agreed upon. And these are the multiple routes that you can take to get there. And what we normally see in shareholder agreements is there isn't just one of these methods. It's normally a combination of these methods layered together like an onion. So an example is this. Shareholders, at the point of the valuation, shareholders will attempt to jointly appoint a single valuer. If they're not able to do it, then each shareholder will appoint their own valuer. Okay, then you can either take the average of the valuation prices, or you can take the middle price or something like that. That one is whatever, up to you. And on top of that, you throw in a curveball and say, oh, the valuers must only be from this list of suitable valuation firms. You can basically mix and match all of these clauses together to see which is the best one for you. And one last thing to take into account when it comes to valuation is this. Parties entering into a shareholders agreement, when they choose to have a valuation clause, should always consider to draft into the shareholders agreement who bears the cost of the valuer. And the reason for this is because valuers, especially the more prominent ones, when their valuations can cost quite a lot. My understanding from one of the more prominent valuers in the country right now is their starting price is, let's say, is about 100,000 minimum. And in order to have a valuation clause, the shareholders must also think how much is the company worth, or how much is the company likely to worth and likely going to be worth. And if it's a small outfit, perhaps they can go back to using a predetermined formula instead of going for a valuation of shares. So finally, this is just a normal conclusion where adequate consideration needs to be given to the clauses. Now, thanks everyone for tuning in. I hope you found that helpful. And if you have any questions, now's the time. You can type your questions into the Zoom chat or on Facebook, and I'll get back on the question as soon as possible. Or if I don't manage to get the questions in this session, you can always email me. My email is there on the screen, and I'll try and get back to you as soon as I can. All right, thank you. Okay, everyone, I'm starting to see a couple of questions come in. Let me address this question from Facebook first. The question is this: can a company allot shares to a director who is not a shareholder but has been borrowing money to the company to keep it afloat? So therefore, can a company allot shares to a director who has been giving directors advances? If some shareholders are unhappy with this, can they take a derivative action? Now, this question is not a question that's directly relevant to the topic of the day, shareholders agreement, but I think I can answer this as well. There is nothing wrong with a company allotting shares to a director who has been giving directors advances. Whether or not the allotment of shares has anything to do, or perhaps the insatisfaction of the director's advances, that's a separate matter. Of course, provided that the company's M&A, all of that allows for this. My understanding is that normally shareholders are able to vote on allotment of shares. So normally in most companies, they have to go through shareholder resolutions in order to get allotment of shares approved because it's a big deal. Of course, this depends company to company. So my answer to that is technically can. It shouldn't be a problem. If shareholders are unhappy with this, can they take a derivative action? The possibility is always there, although it really depends on the specific circumstances if you hit on the factual matrix to get a derivative action. But it really seems that the person who asked this question is asking a very pointed question. And if you would like to reach out to us for any potential legal solutions, perhaps we can help you out with that. My email is right there on the screen. Now, the next question comes from Zoom and is very honest. I'm lost after the type of transfers before valuation of shares. Would you mind to share some examples for those niche transfers? All right, let's hit back very quickly in the slides. We'll go to transfer after put or call option. Now, this is the point where things start to get a little bit interesting. The methods of transfer that we've discussed before this are very common, and you can read up about it almost anywhere. The ones after, which I'm going to go through very quickly, is uncommon nowadays, but I just thought they were interesting. So it's always good to share some knowledge. I don't think we have enough time to go through everything one by one, these 4 clauses that we have here. Can I recommend you to reach out to me and I'll share the slides to you? Anybody who wants the slides can reach out to me and I'll send a copy. Now, regarding the valuation of shares, under third-party valuation, pertaining to additional expert, what kind of expert do you refer to? What can the additional expert do? Now, the answer is, this is an expert who, this expert is actually a valuer. Now, a valuer is normally an accountant, an auditor, somebody who falls into the definition. The powers of the expert, or the powers of the valuer and all these kind of things, it depends on the shareholders' agreement. Now, normally what they will do is that the valuers will do their assessment based on the documents that they require and based on assumptions that they take on, the information that they receive and all of that. That specific details, we can't go into now, but it really depends on the valuer, number one. And number two, it depends on how you draft the shareholders agreement. And normally what we see is that people don't go into the full details of, oh, if the companies were to do a valuation, this is the specific things that they have to take into account. The specific powers and responsibilities of the valuers. And this is actually, normally, it is very open to shareholders just like to leave it to the valuers lah. As long as they can agree on who is the person who will value the shares. Normally, shareholders don't mind being bound by whatever valuation that comes after that, because the valuer is almost definitely a professional who, does a professional job. Now, the question of who shall bear for the cost, that really depends on your negotiation with your remaining shareholder. But just to kick things off, a very common solution to who bears the cost is, let's split the cost, or the exiting shareholder has to bear for the cost of valuation. Those are some examples that you can consider. But as I said, it's a contract and it depends on how much negotiation goes in, how much your remaining shareholders are willing to deal with. So perhaps we'll keep this open for another 1 minute to see if there's any further questions. And if you have, this is the time to reach out. All right, it seems that there are no further questions. If you do think of any after this, my email is right there on the screen. If you drop me an email, I will try to get back to you as soon as possible. In the meantime, thanks everyone for attending this talk. I hope you found it useful, and we'll see you again sometime soon. All right.